Okay then, good morning everybody. Some of you I know from the ELAM meetings. My name is Elizabeth Davey, I'm one of the solicitors at University House Legal Advice Centre. And this is my colleague Jenny Graham, who you probably haven't met, who's also a solicitor at the Legal Advice Centre. Both of us do employment work. Jenny does other things like education as well. So the purpose of today is to deliver training on legal expenses insurance. We're fortunate enough to be funded by the Legal Education Foundation to provide this training nationally, and this is the first seminar. Because it's the first seminar, we are recording it. So the recording is on me and on the slides, so you don't need to worry, you won't actually be in the recording or anything like that. And then, depending on feedback and how the project develops, we'll probably do a follow-up seminar sometime next year. But because we're recording, we'll also be making the recordings available by podcast electronically, so we can provide to people that aren't able to attend. Okay, so broadly today we're going to do an introduction to legal expenses insurance. And then we're going to run through what is effectively the lifespan of a legal expenses insurance case, from establishing whether the client has LEI to instructing the LEI firm on the client's behalf. And then we're also going to be looking at common issues that need to be addressed for LEI casework, looking at how we can maximise our costs, and we'll also be covering regulatory framework and troubleshooting. Briefly, we'll look at potential for developing LEI casework in the not-for-profit sector. This is something that's more with my colleague Eddie Coppinger, who's the director, and this is more about campaigning, because broadly speaking, there's no reason why the not-for-profit sector, if we have adequate insurance and solicitors, can't undertake and do LEI casework just like the for-profit sector and for firms. It's just something where I think there isn't really a culture of it, because in the past most not-for-profit organisations have relied very much on legal aid funding and funding from local authorities and other trusts. With those sources of funding diminishing, it's about establishing and exploring other potential sources of funding. So that is something that we'll be looking at in the background, but mainly we'll be looking at the actual case from beginning to end in terms of what a legal expenses insurance case looks like and how we deal with the insurers. Okay, what's next? Right. So, legal expenses insurance. Some of you will probably know it's can be provided on a standalone basis or as part of cover, which may be included in various types of policies and financial products such as motor policies, credit cards, household policies, annual travel insurance and managed bank accounts. In this country, it generally does come as part of the package, though across the EEA there are some countries that specifically require that it's actually provided on a standalone basis and not as part of the package. And in those countries, I think the Scandinavian countries specifically, if a client approaches a not-for-profit or government-funded legal organisation, they will do a means test, and if their income is above a certain point, they will expect them to have legal expenses insurance cover in order to fund any potential problems that may arise. So typically, cover will include personal injury, consumer law, property and employment disputes, and may award the other party's costs. Some policies don't specify exactly what they cover, whereas others very specifically state exactly what is to be covered. But normally any legal action for which the expenses are incurred must have a reasonable prospect of success, because, as is the case with most publicly funded work as well. And usually, if a client that is funded by an insurer is offered a reasonable offer of settlement, the presumption would be that they must accept it. If they don't accept it, the insurer can withdraw funding. Okay. Most insurance companies will instruct their own firms of solicitors. Some, such as DAS, will even create their own firms. They have a firm called DAS Law. DAS Insurance has DAS Law. And those firms of solicitors will deal with LEI cases on commercial terms that have been agreed in advance. Right, the terms may be agreed on a no-fee basis, or they may be on the basis of a set fee per case. Obviously, with employment, it's likely to be the latter, given that costs are only awarded. So here are some examples of LEI providers. You can see from these slides that most LEI providers will, sorry, most insurance companies will give LEI as an add-on for around £20–25 per annum. Okay, so clients come with a problem, presumably, but for the purposes of this seminar, we're going to presume that the cases that people are bringing are employment cases, because most of you are employment specialists. So most clients that satisfy a not-for-profit means test probably not likely to have LEI. Okay. I know some of you have got charging wings, and I'm not sure how you deal with people's means. I don't know if you assess means as part of that. Any of you here from? You actually you've got green shoots, green routes. How does that work in terms of the charging wing and people's financial
it's what we've done is we've set it up separately from the law centre.
Yes.
So it's basically like any other firm.
I see.
Yeah, we didn't do it like most other organisations do it, which is just an extension of what they're doing, but we are separate.
I appreciate you separate. So people come for legal advice from Green Routes. There isn't a means test.
No, there isn't.
Okay, that's fantastic. Okay, because this obviously, for those of you that don't have that, if you means test people at the door and send people away that have an income that sits above a certain threshold, then you are likely to be sending away clients with LEI, because most clients with LEI are likely to be in the middle income bracket. So if you want to attract clients with LEI, you might need to broaden out how you means test so as you could potentially take on those cases as well. Obviously that's something for you. The reason that we've been able to do so many LEI cases is because we don't have a legal aid contract. We generally don't do a means test, and so we picked up those cases as a consequence of not doing a means test. And our experience has shown us that most of the clients we see that have LEI insurance are usually owner-occupiers, not necessarily all the way up there because they'll just go straight to a private firm in the first place, but they are owner-occupiers and they do quite often work in maybe for the local authority, middle income bracket, just above the threshold quite often for what would have been a law centre threshold. When I worked at Camden Community Law Centre, the threshold was £30,000, and that was about 7 or 8 years ago. So I suppose now it'd be higher if law centres were able to be so generous still. But it's a way of that you need to possibly look at ways of not pushing those people away. Okay. Okay, so what we've done is we picked up that 1 or 2 of our clients, obviously slightly wily, know they're coming to a free legal advice service and think to themselves, if I disclose my legal expenses insurance cover, it might increase my premium next year, and I don't want to pay an extra premium. Also, you'll have some clients that might be very well insured. They might have they might have managed bank accounts, or they might have quite extensive car insurance policies, and they simply are not aware that they have LEI cover because they've just never required it, and they've just and in those cases that's usually where it is provided as standard add-on. There's obviously not an additional fee. So what we've done is we've created a client questionnaire which is loose. I mean, you wouldn't necessarily follow it question by question, but it broadly sets out the type of questions you need to ask a client in order to establish whether they have LEI. I think where you have a client where you suspect they may have LEI and they're not disclosing it, then it's for you to decide how you wish to proceed on that basis. But one of the things we've asked people to do is bring in their insurance cover. And if they're an owner-occupier, they're going to have some sort of insurance. So if they say to us, well, we don't have any insurance, I'm minded to think that they're probably not being honest. Okay, so we've got our first exercise. Dr. Brown?
It should just be in your apps, this one, the title of exercise one.
You just have a think about what you might do and then take a couple of minutes at most. No, I think I've already covered question 1, but can anyone think of anything else that you might do to establish whether Dr. Brown has insurance?
So what was the question?
Okay, so the first question is, what would you do to establish if she has LEI, legal expenses insurance? So as I said, I kind of broadly covered it in terms of questions at the beginning of the retainer, and also asking to see policies maybe. We did actually have a client that was a doctor something, and this is kind of based on them really, because they didn't disclose their LEI to us until they realised they were going to have to pay for a barrister when the case went to tribunal, and then suddenly they found their policy. So, which is leads us to the second question: is if she does have LEI, how would you proceed in terms of offering her further assistance? On what basis do you think you might do that?
If she has LEI, perhaps ask her to contact her provider, insurance provider, and I mean, initially I'll try, depending on what stage the case is. If she hasn't yet, obviously, if it's still at the stage of grievances and dealing with that, perhaps then maybe the insurance won't cover it. So we will do some pro bono work and support with her. Then ask her to contact her insurance to try and find out. In terms of ask permission for her, give her the option that we can carry on working with her if she can seek permission to instruct us. But the option we have. Yeah.
And actually establishing at what stage someone's case is pretty pertinent actually in terms of where we are funding. So yeah, that is one of the first things that we do. And you're right, if you are still at the grievance stage, then you might well be taking instructions and having a chat with her about whether or not she should, as and when she should contact the insurer. Indeed. I think one of the other things as well, obviously, is you might want to, if you are taking it on the case, you probably want to put in the terms of instruction in the client care letter as well, because she's obviously funded by LEI. And the presumption would be that if she was somebody that you might not normally see, because she is above your normal sort of client category in terms of means, or if the LEI wasn't funding her and you were asking her to pay for advice that wasn't funded, you would obviously need to look at how you adapt a client care letter and what terms of instruction. I was quite strict with one client who was really dragging his heels about instructing his insurance provider. This is not the doctor, this is another one, but he did actually tell me he had LEI at the beginning, but it seemed to take him months and months to get around to contacting his insurance provider, and in the end I said to him that I wasn't going to act for him until he actually made contact with his provider. I said I was going to do no further work for him, and he very quickly made contact with his provider. So, you know.
Have you ever actually highlighted how much the pay of your own pocket legal proceedings cost? Is it a way of dealing with people, if you know what I mean? We suspect that someone will have the insurance, but they will be kind of, as you say, a little bit
well,
on the swervy side.
Clear to them that even if we were to take on their case for them, they are going to have to fund certain elements of their case. So if it's a discrimination case, for example, disability discrimination case, they might well have to fund an expert report. they might well have to, they're going to probably have to fund a barrister they'll have to fund the barrister to represent them at a full hearing if it goes to full hearing. And if I wanted to be pushy, I might even argue that they're going to have to fund a barrister to do the preliminary hearing, even though I might normally do that myself, just to see if I could push them to actually disclose the policy. Because once somebody realises the service that you provide might be free, but there are other elements to the service that they're going to have to pay for because there's no funding for that, then they're much more likely to open their pocket to disclose they have a policy, which is exactly what happened to us with our doctor client who was suddenly found his policy into somebody with a PhD. So I find it hard to believe that he didn't realise he had LEI cover until he realised he's going to have to pay for a barrister for, was it 3 or 4 days? 3 days, yeah. And then, well, there it was. Just found this type of thing. Okay, so what are we on to now?
So just on a very practical point, so someone comes through the door to your law centre and you decide to take on, and let's imagine it's still at the grievance stage and they still haven't contacted the RDI. So do you already send a client care letter, or do you? How do you
That's really a decision for you, because I mean I think when we come further into the training, there's a certain point at which it might be ideal to instruct get the client to contact the legal expenses insurer. We're going to come on to that in a minute, but in terms of whether or not you want to offer your service on a pro bono basis until on the basis that you assess that client's case as having a reasonable prospect of success and believe that it should be funded by an insurer, and consequently you might need to take a bit of a hit on the first few hours worth of work you do before the insurance provider confirms it will fund, is a decision for you. I mean, otherwise it could be a case that you get the client to do early work stage and then return, but there's obviously the risk then that they might go somewhere else. Okay, but there are certain points at which it will be ideal to contact the insurance company, and we'll come on to that in a minute in terms of contacting.
Okay, but you as a solicitor caseworker,
it's entirely up to you when it's really a decision for your organisation as to how you structure the client care letter and also the retainer, and whether or not you want to take the client on at an early stage and take the chance that LEI funding might not be provided. Or the case might settle at a very early stage before the insurance company confirms funding.
And typically, in your case, what do you usually do? Do you send
We
a
usually just deal with it. We usually just take a hit. So what we will quite often do is if we realise someone's got LEI funding, even if it's somebody that might live outside our normal catchment, which was the case with the guy with the insurance who kept on delaying, what I said to him in the end is we can't continue to act for you because you are actually living outside of our catchment, and I agreed to do this on the basis that you had LEI funding. You still haven't contacted your insurer. Some months have passed now. There's no excuse for this. You're going to need to make contact with them straight away. And until you've done that, I'm no longer acting for you.
Okay, so you at no point had you at that point sent a client care letter or whatever?
I had sent a client care letter to him, but I've made it very clear in the client care letter the basis upon which I was taking him on. And that's something that you might need to do. You would adapt your client care letter on that basis.
Okay.
So as to state that we are taking this case on the basis that you have LEI cover, and that you will contact your LEI provider, and that you will elect us as your solicitor. If you do not do this, we may dismiss you because you are actually not within our normal catchment, and we have no funding to provide you with service otherwise. Something along those lines. Okay. Okay, so the first thing we had to deal with the first LEI case that we took on was increasing our insurance cover, wasn't it? I think, because it turned out that our insurance indemnity wasn't sufficient. So, as most of you will know, solicitors, the SRA has a compulsory cover professional indemnity, so you have to be covered, and that's specified in Rule 4.1 of the SRA indemnity insurance rules. There is, from a perspective of LEI, there is no industry standard cover. So it's unless the insurer specifies, and some insurance companies will put in place their own terms in terms of what sort of cover they expect you to have. there is specifically from a perspective of regulation, apart from the SRA rules, there is no specific insurance standard. So DAS is a bit high, and to be honest with you, my view is because they have their own law firm, that's probably challengeable, because that works on the premise if you have 10 million cover, that's the type of cover that you might be expected to have if you're quite a large firm. Most of the other organisations we've dealt with have quite lower, or they have no specific standards. They just have an expectation that you're covered in line with SRI. And the SRA rules cover me.
So does that mean that you can't?
It means you can challenge them, to be
Okay.
honest.
Okay.
I know we're going to come on to challenging insurance companies. Okay, so on a general level, in order to undertake LEI work, you need to have suitably qualified staff, which broadly means that you've got a supervising solicitor. And it really helps to have a suitable case management system for recording and billing. If you've got your own, for those that've got like for-profit wings like Green Roots, you've probably developed something like that already. And I think when you go from working on a fixed fee system under what used to be the legal help cover to actually having to record each minute you spend or each 6 minutes you spend and then bill, it does take quite a bit of getting used to, I think.
So just one question. When you say you need a supervising solicitor, if you're the only person doing employment, like in the organisation I'm the only one that's doing employment,
Okay.
does that matter?
Okay. Are you a solicitor?
Yeah.
That should be fine then. It's just a case that actually a lot of the like organisations like DAS Law, for example, I'm going to have to think of an alternative. Will quite often employ a lot of paralegals who are actually working on their cases, and they will be supervised by one supervising solicitor. So they might have like 5 paralegals per supervising solicitor. So if you are getting caseworkers, even I know within a law centre structure, some of the caseworkers are more experienced than some of the solicitors in terms of what they do, but from a perspective of LEI, they would have to be supervised by a solicitor. Even if, strictly speaking, they are, incredibly competent. But if you are the solicitor, it's not really an issue. Okay, so charging wings. I know that some law centres have are in the process of or have set up charging wings. So I don't know what sort of rates are set under your charging wings, but obviously you would need to look at the rates that you charge clients in the community, which are broadly on a sort of not-for-profit basis to actually creating a for-profit charge for commercial work, for LEI work. Otherwise you will potentially be losing money. And that might well be in terms of how you set that up, might be whether or not you have a concessionary rate and a commercial rate. But that's a decision again for you. What was the rate? Okay, so what a lot of insurance companies do is they will generally pay £100 an hour. Some of them a bit more.
So this potential discrepancy between charging in the charging wing and non-profit, this is what can be challenged by the insurance?
Well, it's not what it could be challenged. It's just something that if you have a charging wing and you were to decide and you were going to take on LEI work through the charging wing rather than through the actual charity, then you might want to look at what your rates are and whether you wanted to set different rates. Because what you don't want is if you've got can I just ask you what the hourly rate is that do you have an hourly rate?
It's as you said, we've got concessionary rate and we've got a commercial rate.
That's fine then.
Our concession is 70 for really low, sort of people who we know can't really afford much more than £70 an hour. The concession varies between 50 to 70.
I see.
But obviously if we were doing something like this.
Do you have a commercial rate?
we don't. I need to put it in the system.
And that's the thing. And it's the thing about making sure you've got a commercial rate, because if you could be caught short if all you've got is a concessionary rate, and then the insurance provider's like, well, if that's what you charge, then that's what we're paying you, and then you're realising that you've actually done yourself out an extra £30 an hour, which could be, you know, it's a significant loss. So if you already have a commercial rate, then that's fine.
And that figure of £100 an hour, that would also apply to paralegals or just caseworkers who are not solicitors?
Well, herein lies that you just with certain types of work, you might be expected to instruct somebody on a lower rate to actually undertake that work, but we'll come on to that. Okay, so just broadly, in terms of if you do have charging wings and you are interested in doing any like even if you never charge any of your clients the commercial rate, or you rarely ever charge a commercial rate, you should set one in any case, just so that you can maximise on any LEI casework you do. Okay, so this is I can barely see this. Can anyone see it? Okay, so this is the applying the LEI process now, applying for funding. So the client contacts the insurance company. The insurance refers the case initially, in the first instance, in-house or to a panel for assessment of merits. And a decision is made by the insurance company. That decision may be to agree to fund, and then we come to the issue of choice of solicitor, or not to agree to fund, and then there's the need, if the client so wishes, to challenge the decision, and then possibly seeking the barrister's opinion. So this is the frame. So we're going to move on to the next one. So the client contacts the insurance company. Now, again, clients that like to drag their heels could well be called out, and it's another thing that one can do if you've got somebody that first comes and they're dragging their heels about contacting their insurer, or you think they might not be disclosing that they've got insurance, is pointing out that most insurance companies do have a deadline for applying since the Act to actually getting insurance, which is generally 180 days. So that's okay for employment work, because the deadline's so short in terms of instructing and then in terms of filing a claim. But obviously, if you're at the doorstep of the hearing and then the client suddenly discovers their LEI policy, it might well be a problem, because the insurance company might say, we're not going to fund you because more than 180 days have passed. So this is another thing to be aware of.
Is it from the date of the act you want to complain about, or from the
that would depend on the insurance provider, because the 180 days is not set in stone. There's no insurance standard. But when we looked at the different policies, a lot of them will actually have a deadline, and the deadline seems to be pretty much averages out to about 180 days, doesn't it? It seems to be the most common deadline. That's
but from which
it doesn't specify. You would probably have to go into the very small print of the terms of the policy to establish whether that is from the actual Act itself, or whether that's from filing the claim.
Okay. And in your experience, what is it?
In my experience, this is actually something we've not today had a problem with. So it's not something we've had to challenge yet. But we anticipate that at some point we probably will have to challenge it, particularly if somebody rolls up at the last minute and they turn out to have LEI cover.
I suppose they also don't. If you get the insurance after the incident, it's one of those things.
You won't be covered. I mean, that's the thing. LEI, another name for it is before the event insurance. So you would have to be covered before the event, and that can be a problem too. But we will come on to. After the event insurance is something very different, and it's generally something that I think with no win, no fee cases that some solicitors take on, they will take out and out. The client will be expected to take on an after the event insurance, which is quite pricey. But that isn't something we're dealing with today. We're specifically dealing with before the event insurance. Okay.
And I'm sorry to be bothersome. When you say the LEI makes an assessment refers the case in-house or to panel for assessments of merit, are you as a caseworker asked for?
Well, we're going to come to this. Okay. Honestly, we're going through prospects of success now. Okay. So reasonable prospect of success. 51% or more chance of winning. That's actually been, that's a decision of the insurance ombudsman, isn't it? A financial services ombudsman, that generally speaking, they will, if people complain, they will argue that a case has to have a 51% or more prospect of success in order for it to be funded. So legal expenses policies invariably contain a clause that allows the insurer to withhold or withdraw funding for legal action or defence. FSO interpret reasonable prospects, as I've just said, as 51%. So a legal expert says 50-50, unfortunately, client won't be funded. So it's got to be 51+%. For those of you that did legal aid work, you'll probably remember they'd ask you about what sort of prospect of success you thought a client would have, and I mean, an extra 1% doesn't really.
So if you phrase it like you've got more than 50%, would that be sufficient, or do you have
I
to
think you would
spell
say
it out
51% or more
51%?
specifically. Yeah, you'd have to make that assessment. And that I frequently do this with my cases because I was very reluctant to actually specify a percentage that I thought clients might have of success, but I think over time I've just come to conclude that
Basically,
that's
you
a
have
good.
to
But
put a figure.
with all casework, as the case develops, your view in terms of prospect of success changes in any case. But in the first instance, on the instructions and based on what evidence you're provided with, you have to take a view on whether or not you think a client has 51% plus chance of success. It might be difficult in the first instance, as we know, and quite often we don't really know until we look at the ET3, but it's just, you know, that's just something that would be expected to do.
And just normally I intend to put it like more than 50%
Yeah,
success.
more than 50%.
That's might not be worth.
And so practically, is that what you usually do? You just say, okay, 51% and don't go higher because
Well,
it's a very...
no, I think that just looks a bit. We'll usually. I mean, the thing is it's about what the insurance company thinks ultimately. And if the insurance company assesses the case, that we'll be looking to see what they've assessed it at in terms of what we come back with. Okay. So the insurer must be satisfied that you've got reasonable or better than average chance of winning the case. Otherwise, they won't fund it. That's the bottom line. So, just because the insurance company says we don't think this case has a reasonable prospect of success doesn't mean to say that it doesn't. And we've dealt with a few cases where people haven't been funded in the first instance. So one of our cases, rejected by the insurance, no merit to the claim, it actually won its case at tribunal and the client received £65,000. So you'll probably appreciate from that. Other cases that the insurance have refused to fund of ours, they've once on challenge they've all been funded and the cases have all settled. So on that basis you appreciate that the insurers tend to, if anything, assess downwards. So it's our job to challenge quite often homes or decisions. Okay, so this is one of our case studies. So Mrs. A was outside our normal catchment area. Complex race discrimination claim, and had already contacted her insurers who'd refused to fund her employment tribunal claim. The matter had already been referred to one of their panel solicitors who had taken the view that her case did not have a reasonable prospect of success. The case was referred to us to see whether we could help. So basically what happened with this client is she actually approached us at that point because she didn't think to come to us before that, but when she didn't get assistance from the insurance company, she came for advice about how to challenge the insurer in terms of whether or not she could, how to put her appeal. So we assisted her with that. So we reviewed her case and we took the view that her case did have a reasonable prospect of success. What we did at that stage is we obtained counsel's opinion and counsel agreed with our view. So we then contacted her insurance provider, insurer providing counsel's opinion. So the insurer changed their view of her case and appointed us to represent Mrs. A, because by that time she obviously was very confident with us because we'd helped her to get insurance funding, got her a barrister's opinion and so on. So we were provided with the company's terms of business for non-panel firms and solicitors. Right, terms of business were quite restrictive, but we managed to negotiate away a number of its problematic provisions. So the case eventually settled for £50,000, and on conclusion of the case, we were able to negotiate a more favourable hourly rate, and that was contained in the original terms of business. So that's one of our own case studies. So the lesson from that is, just because the insurance company says we don't think this, or this is what we will do, and this is what we'll pay for, it's always possible to negotiate with them.
Sorry, how did you find counsel's opinion, or would the insurance company have paid for that, even though it was prior to them agreeing?
We're going to come on to counsel's opinion. Okay, right. What happens if
Will you also be covering how you negotiated a higher rate than was originally covered later on?
We'll look at that, yeah. Okay, so what happens if the insurer refuses to fund the claim? And this might well happen in the first instance. I mean, expect that to happen is what I would say.
Just sorry to go back to basics. Do you? It's a client who obviously contacts the insurers, but do you sometimes write a little summary for the client to bring to the insurers and giving a summary, giving your opinion as to the chances of success of the case?
We can do that, yeah.
But is that something that you usually do, or?
Well, we would assess, yeah, but as I said, we're going to come on to how we interact with the insurance company. So the insurer refuses to fund the claim. So it's not unusual for an insurer to say things has got less than 50% chance of success. So we've got rejection letters.
Yeah, so in the pack there was a rejection letter.
Have you found the rejection letter? Okay.
In this rejection letter, it says we've received notification from your solicitors, which suggests that they had been appointed. Was that because they were they appointed them themselves?
Okay, so this wasn't us, no. This wasn't actually one of my cases, so I'm not sure if it was that it was the panel solicitors who had assessed and just made this decision, or if this lady had instructed her own private firm and they'd done this assessment. I'm presuming it would have been the latter, the former rather than the latter, because my presumption would be that a privately instructed firm would be more likely to argue that the case had prospect of success. What we'll do is we'll double check with the caseworker in this case, because it is a bit confusing.
I think it looks like it's the panel solicitors,
Yeah.
but still you refer them those solicitors as the client solicitor.
Indeed, that's right.
Because
I
they are
think
not the insurance solicitor.
My
technically.
understanding was it was the panel solicitors.
Yeah.
And that was what happened there.
But even before you come to that, when you tell your client to go and contact their LEI, do you at that point provide them with a little summary of their case and with your opinion?
Yes, so if somebody comes to you at that stage and they come to you waving this letter, what I would be minded to do is get them to provide me, if they'd already filed their claim, I'd obviously want to see their ET1, ET3 and other relevant documents. If not, I would want to, if I hadn't actually got to filing yet, I'd want to take like full instructions and then establish on the basis of their instructions and any evidence that they might have.
But even before that, even if the client comes to see you having no idea that they've got LEI, and then you tell them, well, actually, it seems you do have LEI, go and contact your insurers. Do you at that point provide them with a summary of their case and your view of the prospect of success to help?
Yes, I would.
To
be honest with you, when anyone comes through my door for advice about their employment case, one of the first things I'll do is I'll look at the papers and I'll take their instructions and I'll generally give them broadly speaking, an assessment on whether or not I think their case has got merit or not.
Yeah,
Now,
in
I might
writing
give them
that-
no, not necessarily, because some people I will deal with on a one-off basis, and this is just in general, because it might be that I just take a view that their case has no prospect of success, and so if they had LEI, they can have 5 LEI policies, but if I thought their case had no prospect of success, I wouldn't pursue it any more than I'd pursue it if they didn't have LEI case, if they didn't have LEI case.
But if they do have LEI and you think they've got some prospect of success, do you then at that point provide them with something in writing that they can bring to the LEI panel?
Not necessarily, no. I would ask them to like show to sort of contact their LEI provider and then take.
So it's only once the
But
LEI
again,
has made a decision.
depending on the stage that their case is at. It's like Monsa was saying, that you would, well, one of the first things you might do is establish with that client exactly where their case is. And if it's at the very early stage, like if the act, say for example it's a discrimination claim, if the act happened like 2 days ago, then no, it might be a bit premature to be contacting the insurance company. If an ET1 and ET3 has already been filed, then you would want the client to contact the insurance company as soon as possible. Okay. Yeah, I mean, with one of our cases where we were instructed before, we actually did complete a form, it's generally the same in her case, where we actually specified what we consider to be the prospect of success. So if a client goes to their insurer and they say, I've already got my own solicitor, then one would anticipate and expect that the insurers would at least get your opinion before they refer to.
But you don't willingly give it, you don't spontaneously.
You might want to, yes. You might advise a client to provide a copy of the advice letter, for example.
Okay.
I did actually suggest to one of my clients that they provide a copy of the advice letter to the insurers.
Okay.
Okay, so the insurers rejected the claim on this basis, no prospect of success. So options for the insured person are that they can appeal, and then failing that, they can complain to the FSO. Okay, second opinions. So, second opinion from a solicitor of comparable experience or barrister. So, and this is where we come to your point about second opinions. You can give a second opinion if you want to. So if the panel solicitors have said that they don't think the case has got a prospect of success, you might want to find out from the insurance company exactly who did the assessment, what their post-qualified experience is in that area. And then if you can match that or you've got a better level of experience, it's definitely worth giving a second opinion to say that you'd actually dispute their view, you think the case does have a prospect of success and these are the reasons why. The other thing you can do, of course, is seek the opinion of a barrister. Now what the FSOs say is that if there are 2 solicitors and there's a dispute in opinion, then the insurance company should pay for a barrister's opinion. So it is worth giving a second opinion on the case, or in the alternative, you can contact the insurance company and say, we think the case does have a prospect of success, we're going to challenge it on that basis, but we want you to fund a barrister's opinion. And in most of the cases we've dealt with, the client has been able to negotiate that the barrister's opinion has actually been funded by the insurance provider.
But then is it a barrister chosen by the insurance?
Well, herein lies the thing. I mean, if you go to them with a second opinion and ask them to fund the barrister's opinion before the barrister is instructed, it might well be chosen by them. On the other hand, the client might be able to negotiate with the insurance company and say, if I get a second opinion from a barrister and the barrister confirms that my case has more than a 51% chance of success, will you fund that opinion? And most of the time they say yes. In some ways, the latter route is better than the former route because then the client at least gets the choice of who they instruct. But they might well have to accept that if a barrister comes back and says, sorry, I'm minded to agree with the insurance company, then they have actually lost that money. But that's a decision for the client. So in terms of second opinions, and as I've just said, if you get the insurance company to fund the barrister's opinion in the first instance, then there could be delays because obviously you've got to get them to agree to the funding, they might want to instruct their own barristers, so on and so forth.
So while all this going on, effectively you will be doing it pro bono.
You will be. Or you might well have negotiated for your client to pay.
Then you reimburse them.
And then you would in terms of insurance, what's going to happen, and again this is where negotiation comes in, if your client, say, contacts the insurer on the 1st of July and the insurance company come back with an assessment 2 weeks later saying we are not going to fund your case, the case is running, you appeal, and then around about the middle of August they agree to fund it, there's scope for negotiating that they should fund it from when the client actually first made contact, because the appeal has been, has been upheld, and that's something that is definitely worth negotiating with them, saying, look, it's not acceptable not to fund that 6 weeks worth of work. And if they refuse to, then it's possible for you to complain to the FSO about them and say that this should actually be funded. They shouldn't be able to benefit from their own bad decision in the first instance. They've now agreed that the case has got a prospect of success. In the circumstances, they should be funding it from when the client contacted them and not from when they made their second decision.
Would it look a bit iffy if you take some money from the client and say, like, if the insurance pays it,
It's a decision for you. I mean, we don't actually have a charging wing, so we can't comment. But so what we've always done is we've always tried to maximise on how much insurance we can get, because we don't charge clients for our work. So the consequences are, if you want to actually do it within the context of having a fee-based system in place to sort of supplement the insurance policy, then it's for you to decide how you go about that, whether you do it on a pro bono basis or whether you do it under a fee pay basis. That's a decision for your organisation. Okay, so just in terms of the slide that we've just missed there, I mean, it might well have hit the point, as you say, where you've had to file the ET1 because time is running.
Yeah.
And then again, it's about, you might be able to argue with the insurance company that they should fund the work you did there because you had to preserve the position of the client. And if you'd have carried on basically like arguing with them, you would have missed the deadline for filing the claim. So second opinion from a barrister. Do you have pro bono connections? If so, you might wish to exploit them by asking for an expert to draft an opinion either for free, on a pro bono basis, or at a reduced cost. We've managed to get barristers to do at a reduced cost. Have we had any free opinions? We haven't had any free opinions. We've usually been able to get the insurance company to cover one way or another, so we've not had to ask anyone for a free opinion. But this is a case of where it's also, if a barrister thinks it's going to run, and they've already assessed the case, and they do it on a reduced rate, they well know that you're likely to instruct them to undertake their full case hearing as well, and that will be at a more reasonable rate, because curiously insurance companies don't seem to argue with barristers' rates in the way they argue with solicitors' rates. Okay. So it's worth checking the clauses of the cover and or negotiating with the insurer to see if the insurer can pay for the barrister's opinion. I've already covered that. As I said, my view is it's sometimes better for the client to be able to potentially instruct their own barrister and make sure they get the money back afterwards than getting an insurance provider to instruct. Even though we're all supposed to be impartial as lawyers, it doesn't always work that way, as we know. Okay. Social goods on this side. Okay, so the insurer decides to fund the claim. So we've gone past the appeal, etc. And now we come to choice of solicitor. So, pre-litigation stage, if the insurer considers that a claim should be pursued, the normal practice is for it to be passed to an external firm of solicitors on the insurer's panel or the insurer's own firm. Legal expenses policies often give the insurer the freedom to choose which solicitors to appoint for advice and assistance up to the time where legal proceedings start, unless there is a conflict of interest. So insurers have panel solicitors whom they regularly instruct. So the issue here is, will the insurer fund the client's chosen solicitor to act before proceedings start? So if it does come to pass that the insurers have agreed to fund and the case hasn't been filed yet, then the issue is whether or not they'll fund you. They're not legally obliged to. Sometimes they'll have no objection with the policyholder choosing their own solicitor, but often they'll prefer to fund a solicitor from their own panel. So, pre-litigation options. So if the insurer will not fund the client's chosen solicitor, there's a potential for the client to negotiate with a provider. The client can complain. Ultimately, that goes to the FSO, although from the cases the FSO has adjudicated on, they're only likely to uphold a complaint if there's a conflict of interest or exceptional circumstances in the client's case. So they're more likely to agree that your client should be able to choose their own solicitor in cases that have complex personal injury or medical negligence cases, significant boundary or employment disputes. So especially if there's a considerable history to investigate and assess. Home solicitors have already had considerable involvement in the issue giving rise to the dispute or related matters that don't rely on this. In very sensitive cases, so this might say include a sexual harassment or a complex discrimination claim where the client's already discussed the matter with their own solicitor and they benefit from face-to-face contact. Okay, so after proceedings have commenced, so once a claim's been issued, once proceedings start, and that is effectively once the ET1 has been filed, or if there is a conflict of interest. Regulation 6 of the Insurance Company's Legal Expenses Insurance Regs states that the policyholder is allowed to choose their own solicitor. That is legislated upon.
So you have to start off doing quite a, because if you take quite a bit of work, from the time you take initial instructions, go through all the papers, put the ET1 in.
I mean, if you can try to get funding before that, but we take view from the cases that we've. I mean, what's normally happened, to be honest, is because the insurance companies quite often refuse to fund in the first instance anyway. By the time you challenge, you had to put the ET1 in any case, or you're at the doorstep of putting the ET1 in. So that's quite often been our experience. I mean, it's unusual for somebody to rock up like one day after, like the last act they're complaining of, and contact the insurance company the next day, and the insurance company does an assessment and says, okay, we'll fund this case. I mean, that just isn't what we see happening, to be honest. So although it looks quite daunting, like, oh my God, I've done like all this work on this case, our experience is quite often by the time the insurance company agrees to fund you, the ET1 has already been filed or is about to be filed. So my view would be it's probably worth filing the ET1, and if the case is under appeal at the time, then there is always scope to argue that you should be paid for filing the ET1 because you're preserving the client's position. So as I've discussed, if the client contacts the insurance company, say on the 1st of July, but after an appeal, they don't get their funding to the middle of 6 weeks later, then there is scope to argue to be paid for that work because you were protecting the client's position, particularly in submitting the ET1. So there is scope to argue there. But if the insurance company conversely says they will fund the case from the very beginning and the ET1 has not been filed and maybe it's still with ACAS, then it might well be worth, you can argue what you want the case to be. You could even say, the client can say, well, actually, as soon as my ET1 is filed, I'm going to select my own solicitor. So you may as well fund my own solicitor from the beginning. But if the insurance company refuses to do that, then it's a case of whether or not you. It's a case then, I suppose, that it would have to go to panel solicitors and then back to you. So that technically could be quite tricky. So it might just be better to
just put the work in.
Just to put the work in.
So can the client, can the insurance says, okay, no, we'll choose our own solicitor, but then the 81 is filed, and then can the client say, okay, then
Yeah,
from
that's
now
right.
on, I'm changing solicitor.
Absolutely.
and
They
I'm
can say
changing-
as soon as they get that letter back from the employment tribunal saying your claim's been accepted, they can then contact the insurance provider and say I'm instructing my own solicitor.
Okay.
And that from that moment in time, you should be paid for the work you do.
Okay,
I
but
mean, I
if,
think what would happen is the insurance provider would have to send you their terms of service, and you would sign the paperwork off. There's no reason for the insurance provider to refuse to fund you from that point on.
okay, so in every LEI case, actually, clients can choose their own
They
payment
can
structure.
from the point in time when the claim is filed, and that's actually legislated upon. It's not something. Obviously, insurers might try to find ways around it, like silly, like £10 million covers. And I think there was one case where they non-panel solicitors were offered £750 fixed fee kind of deal, but that type of thing. But all of those can be dealt with, negotiated away, and certainly the cases seem to suggest that where an insurance provider tries to put barriers in the way of a client being able to instruct their own firm of solicitors from the point at which proceedings start, the FSO will generally uphold the client's complaint and allow the client to proceed on the basis that they're instructing their own solicitor. So, client selects you to represent them. What next? So what will happen is the insurer will provide their standard terms of appointment. So what are the terms of appointment?
Yeah, so we've got two examples, one from DAPS and one from Family Plus.
Okay, you can see from these two standards says that they are completely different. And this is again reflects the fact that there aren't really any industry standards in terms of what to expect in terms of what sort of insurance cover you've got and so on and so forth. So there you have. Okay, so whilst you're flicking through those, two of the matters that you'll need to be aware of before you sign off: does the insurance cover you, and what will you be paid?
The insurance you're referring to there is your own firm's insurance, isn't it?
Yeah, sorry. So what your insurance,
Yeah.
as in i.e. your own company's, not your client's policy, but your insurance, what does it cover you in terms of what is the indemnity? Now with a Family Plus policy, you can see it doesn't actually specify an amount. So the presumption would then just be that you fall to the SRI regs. Other insurers will specify an amount. And what will you be paid? What's their hourly rate? What are they going to pay you?
Okay, typically on the Family Plus one, it says that costs will only be indemnified for work done by solicitors qualified and registered with the Law Society. how do you deal with this? Does that mean that?
Well, like I said, I mean, as I said at the beginning, you generally have to have a solicitor acting. Okay, now specifically with Family Plus, because it isn't the case in all of the policies. Because, like for example, with DAS, their own law company certainly doesn't have solicitors acting on all their files. We actually wrote to Family Plus when we wanted a trainee to undertake certain work and asked if that was okay, and they generally agreed to that, because otherwise, well, it's fine. If they want somebody that's 5 years PQE, basically like putting together a trial bundle because they want a solicitor rather than a trainee to do it, and they want to pay my hourly rate instead of theirs, then that's up to them. But generally, they'll agree if it's if it's not that's not work. But otherwise, they would expect a solicitor to be acting. So as I said, it is the case that with this policy, I mean, with other policies, you might be able to get around that. But the general presumption is that you would need a solicitor at least supervising, but if not, actually certainly being the case manager as well. But you'll know from most I don't know how many of you've dealt with. I've dealt, when you deal with firms, respondent firms, that where the company is obviously covered by ODI, you are quite often dealing with non-qualified solicitors. So there are ways around this.
That's true.
So. Okay, so many insurers have clauses that limit their liability to the hourly rate they pay their panel solicitors. What they shouldn't be doing, and there's cases from the FSO that support this, is they shouldn't be offering non-panel solicitors less than their panel solicitors. They shouldn't be saying, well, we'll pay our own panel solicitors £110 an hour, but we'll pay non-panel solicitors $50. They're not allowed to do. They're generally not going to get away with that, and that can be challenged.
So is it the maximum they can pay is what they pay for the panel?
Well, you can potentially negotiate more. There are FSO cases where the FSO has upheld the client's complaint, where the client's complained that their panels that they wanted to instruct their own solicitor that has a higher hourly rate. Generally, the FSO will not uphold that type of complaint. They will just say, well, look, it provided the insurance company isn't actually imposing terms that frustrate the policyholder's choice, completely frustrate the policyholder's choice. That they're usually expected to agree to work for the insurer's hourly rate. So, as I said, the hourly rate tends to be around 110 pounds, sometimes a bit more, sometimes a bit less, depending on the level of qualification of the solicitor. From the perspective of the not-for-profit sector, that isn't necessarily an unreasonable rate. I mean, if you're working for a commercial firm, a lot of commercial firms they wouldn't touch insurance work because it just doesn't pay for them. But from a not-for-profit, from the perspective of not-for-profit, it's possible that it might be okay, and it's possible to negotiate a higher rate potentially. But that depends on the insurance company and what your argument might be for justifying that.
Do insurance companies have a cost versus benefit test as well? For example, if the client's only likely to recover, say, £8,000 damages.
Generally, they would be not necessarily. They usually have. I mean, if the case has got a very low value, then there might be a limit on how much they're likely to fund. But most of the cases, if you look at the standard terms, they usually limit what they'll fund the case to £50,000. Some will fund to £100,000. So. And that would include any costs that have to be paid out as well. So obviously, from an employment perspective, this isn't necessarily a problem. I think for a personal injury case, this could be really tricky, particularly a complex personal injury case. But from an employment perspective, it's likely that it's not going to be a problem. And also, one of the arguments in employment, particularly where you have things like disclosure and discrimination, is it's not always about the actual financial reward, it's about the actual act that the employers the unlawful act. So it would be well easy to argue, well, sorry, this claim might only be worth £15,000, but it's a direct discrimination claim. The client should be allowed to take it to the tribunal. So one of the things that is generally the case is that in insurers, in the policyholder's own copy of their insurance policy, it will rarely ever specify the rate, the hourly rate that they will pay in the event that the client has to instruct. But what the Financial Services Ombudsman say is if the terms of the policy are such that they're likely to frustrate the policyholder's choice, because they do offer like very low, they basically put too many barriers in the way, then they should specify them in the policy, because if they don't specify them in the policy, then they can't rely on them. Here we come to the leading on from that, we have unreasonable terms of appointment. So, to try and get round not the client not wanting to instruct their own panel solicitors, there are various things that the insurance provider might do. For example, have ridiculously high insurance levels required. Some of them might even specify a turnover, that the firm has an annual turnover of X amount of money. Querying qualifications is another one. And specifying that the firm needs national coverage. In our experience, these things can be challenged. We had one case that imposed, I think it was it national coverage and turnover, and it was something we challenged, and it was accepted that we could act. Because to do that is to really try to restrict again the client's choice to such an extent. The client might not want a firm that's got national coverage. Client might not want a firm that's you can't necessarily also restrict in terms of turnover, because you effectively take out a lot of firms, you certainly take out the not-for-profit sector. But all of these things can be challenged because they're not really acceptable terms. They are just hurdles, and they're just ways of insurance providers trying to ensure that their own panel solicitors are used. Because a national firm with a high annual turnover is likely to have an hourly rate that is above what an insurance company is going to pay. So effectively, it's like trying to deprive the client of choice.
Can I just ask how much time you found it takes to challenge?
That's right.
Because I'm just thinking there's quite a lot of different insurance
There is quite a
companies.
bit of work, but to be honest with you, when I used to do legal aid work, you spend just as much time messing around doing that as well. So it really isn't that different, to be honest with you. It's not that different at all. So you spend a lot of time that's non-chargeable challenging, like, you know, we're dealing with those legal aid cases or getting them to pay for exceptional cases and so on and so forth. As it's the same with this.
And once you've challenged an insurer, is your experience that then they kind of think, oh, we'll just let them do it next time? Last time we tried not to let the client instruct them, it ended up being, because it's grief at their end as well, isn't it, in terms of they've got to respond? Or do you have to fight the same battles?
I mean, I mean, there was one case that I did. I mean, they usually will back down before it goes to the FSO. But that's been my experience. They generally don't want it to go to the FSO. And I mean, I threatened them, like I was quite happy to take a complaint onto the FSO in one case, and it was over a very small amount of money. But I frankly, I'd had enough, and I was just quite, I would happily put in the time. And I made that very clear to them as well, because I wasn't happy with the standards of service the insurance provider had in terms of the way they treated us. So my view is that they'll generally back down.
So your experience is that they are as difficult insurers as in any area of insurance, in other words, because making any insurance claim is a pain.
That's absolutely right. I mean, their job.
So is it kind of the same relationship, full of hurdles and pain?
Indeed, and the more you're more familiar with it you become, and the more experienced you become, the better you become at sort of minimising the amount of time you spend challenging the insurance provider.
I would
Their
assume
job is to pay out as least money as they can possibly get away with. They're a company, they're there to make a profit, and that's ultimately the bottom line.
So basically it becomes routine at some point. They probably have some routine behaviours.
You expect certain things, yeah, like you expect claims to be like, even the best cases to be, you expect the that you're going to have to challenge the initial decision, for example. That's something you expect to do. You're almost prepared, your kind of your opinion, and you've already chatted quite often to council before you've even sent it to the
This is what I'm
insurer.
asking, because it looks like it can be operationally planned.
Yes,
all these hurdles,
Indeed,
you
it
kind
can.
of
And,
plan them
you know,
into the
in the first
workload.
instance, like we kind of learned the hard way really by through experience, and I mean part of the purpose of this is to actually enable people to kind of work around those hurdles and minimise their time as much as possible by kind of knowing what to expect and how to deal with it, and also knowing what the insurance company can and can't get away with, and yeah, ultimately that's pretty much okay. So, you've been funded, the insurance company's paying your hourly rates, and so on. You've signed the terms. So, you are now effectively acting for the insurer as well as your clients. So, in the terms of agreement, there'll be notification requirements. You will be expected, generally, to let the insurance company know if any settlement offers are made. So even if the company contacts you, or the respondent solicitor contacts you and makes a commercial settlement offer of £500, and you know the claim to be worth way more than that, you would have to notify the insurance company. But what you will generally do is say, this is not an acceptable offer of settlement, it's just a commercial offer, and therefore we do not think that our client should accept this offer. Generally, the insurance company is usually fine about that. It's once the offers start to get higher, and it's when the offers start to get higher, and you might have a client that's set their sights on quite a high settlement, that you might need to actually have a little conversation with them about your obligations and say, look, there's a chance if you refuse this settlement because it's reasonable, because it might be, say, for £20,000, and you've assessed the claim as being worth about that much. Maybe give or take a couple of thousand. It might be at that point you're saying to the client, look, I've got to notify the insurance provider, you've been offered £20,000, I can't get the offer up anymore, I've been trying, I can't get it up anymore. There's a chance that they will refuse, they're going to ask my opinion about that, and there's a chance that if I give my opinions that that's what I think is a reasonable settlement offer, that they're going to stop funding you. And you do need to make it very clear to
So I
them.
suppose
We've had
that
that
would-
happen with
You would
clients
have to
as
put
well.
that in your letter, because it could get very difficult
Well,
once these settlements start coming
yes,
in.
but you are, I think this is a thing that the client needs to be aware
Yeah.
of, is that once you're instructed by you would amend your client care
Yeah.
letter. So
Yeah.
when I've taken cases on before the insurance has been accepted, I've then sent a new client care letter out, setting out the new terms of appointment, and also attaching a copy of the policy, which I usually have a copy of anyway, but just to let the client know that this is what I've signed up to, so you need to be aware of these things. Also, you are normally expected to notify the insurance provider when new evidence comes to light, which might change the merits of the case. You know, it's that moment where disclosure happens, and you look through something and you think, oh my God. that obviously you'd be taking your client's instructions on that evidence first, but you know, if you really felt that it changed the merits, you would be expected to notify the insurance provider. And most providers do require an update at set stages. And by the by, they generally don't pay you for these things. It's not something that is part of your hourly rate. And whenever you've got disbursements, you'll need to apply for them. My experience is that they're pretty easy on the old disbursements. They're quite happy to pay out for disbursements. A bit like legal aid, really. They seem to be happier to pay out than they used to be anyway.
So you can't charge for the letter to the insurance company.
No, the correspondence with the insurance company is generally not part of the same thing. Okay. So I think I've already touched on this. Many independent legal firms, they won't be able to take on work required at the insurer's rate. But I think law centres and not-for-profit sector providers are potentially in a really good position to undertake work at the rate that's provided, or even at a slightly higher rate if it can be negotiated in more complex cases. And again, I think that might, in certain instances, give NFPs an industry advantage. particularly if you can bring on pro bono assistance as well to a certain extent, you can then help to fund the work that you don't actually get support for, or you don't get funded for. Okay, so in terms of the actual rates, Court of Appeal decision, which I'll let you read. So we've covered that, but that is actually the legal position.
So,
Sorry.
so in practice, do you ask your client to provide you with before you do anything, do you ask your client to provide you with the policy, and then to ask the insurance to give you the standard terms, the standard terms of appointment, so that even before you start the case, you sort of have a big idea of how much you're going to be.
Our experience is that most of the providers pay around about the same amount of money.
And that's about £100.
So it won't actually specify in the client's policy.
But usually you just assume that it's.
Yeah, we make that assumption.
And it's
I guess we could. It might be sensible to ask what they want, and it's certainly something the client would make inquiries about, because if the client wanted to instruct their own solicitor, then they would want to know what the hourly rate is in order to be able to go and negotiate with their own solicitor with firms.
But in your experience, it's about £100 everywhere.
Okay, and so in terms of the actual annual, the hourly rate, the annual rate, there's this particular case where the insurance company, the court didn't conclude that the amount offered by the insurer would always be acceptable. It does say that legal expense insurers have the right to restrict what it would pay to a non-panel solicitor, provided the remuneration is not so low as to render the policyholder's freedom of choice meaningless, which we've covered. So if choice has been rendered meaningless, the policyholder should be made aware of that at the point at which they purchase the policy. It's pretty much the expectation of courts. And if the non-panel's solicitor's rates are reasonable and necessary, so for example the insurer is trying to pay a significantly ridiculous sum or is trying to restrict choice, if your own fees are reasonable and necessary, then you've got very good grounds to argue that the insurance company should pay them. It's unlikely that in the not-for-profit sector the fees would be unreasonable. Okay, so I think we've come to the first break. Just waiting for the tea to come. If anyone's got any questions?
Sorry, could I ask just one question? So, in the Family Plus terms of appointment, it talks about costs. In like normal, like when you do housing legal aid, you're expected to recover your costs if you can. Is that the same principle here? Because we wouldn't.
Not really, no. I mean, you might be expected to. I mean, with employment work, you generally only cover costs exceptionally, and so the insurance provider will also know that.
Right. So even though it's in the policy, they would know this.
They wouldn't expect you to recover your costs. But I suppose if the respondent behaved very unreasonably and you did put in a cost application at the tribunal, that would have to be for unreasonable or behaviour. Yeah. Then they might challenge that.
But it's okay to sign the terms of appointment even if it's got the costs.
It is, because you would talk to them about that. But I mean, it's standard practice that you don't recover costs in the employment tribunal, so they can't expect you to do something that isn't, that's outside. I mean, because you have to remember that LEI covers, one of the main areas it covers is personal injury, and in personal injury claims, the standard practice is that you always recover your costs. So I guess it's often it's going to be likely a reference to civil proceedings, but in the employment tribunal you would not be expected to automatically put in a false application. No.
Can I ask a broader question? Have you done any work? Because I'd imagine quite a lot of people haven't really looked at that. You know, they've primarily taken out insurance for one thing and they haven't ever really looked at it. And it may never occur to them, even if they have got an employment issue. Have you done work specifically to kind of raise awareness, and also they're not necessarily typical NFP client group, to encourage people to think about, not quite like, did you have an accident, would you like to get some money? But it kind of, you know, if you're having a difficulty at work, you may not realise you've already got...
Yes, we are actually currently in the process of doing that. We've actually been funded by the Trust for London to do an advertising campaign around London early next year, to raise awareness about LEI. And we're also looking to do also some work in terms of campaigning, because one of the issues is that certain companies, like for example, household insurance policies, the local authorities and housing associations quite often buy bulk policies that they offer at lower rates to their tenants, but they generally don't include LEI. So one of the things that we're also doing, as well as doing the casework-based stuff, we're also doing campaigning work-based stuff, where we are looking to negotiate and maybe try to campaign to actually get that brought into policies. Because, for example, if Tower Hamlets Council were to include LEI as a cheap add-on for the tenants that take out insurance policies with them, then that would increase coverage of LEI significantly. And given that what we're seeing increasingly are a lot of people coming to the centre that are not necessarily, they would fall out of the side of a means test, but they don't have insurance cover because they can't afford to instruct privately. And we're seeing that more and more. And it's people like this that really need to think about getting that cover or having that awareness of it.
May I just ask, maybe that might be a silly question. I know that was just at the beginning, but I will just come back to your typical legal expenses insurance covers certain areas, or
yes,
does it
generally
cover
it does.
all legal expenses linked
well,
with
some of them don't
representation?
specify. Some of the policies don't specify, but most of them will specify. And generally speaking, they will cover things like personal injury. They'll cover any property disputes that might affect the policyholder's property, and they'll cover employment disputes. They pretty much all cover employment. I've not seen one that doesn't. And some of them will cover other areas as well, like generally consumer rights are covered as well. So the sorts of things that they would expect, you know, somebody problems that the average person may face, and the average person, the type of issues that people come to you with, if they're not in the sort of very much in the social welfare spectrum, are things like employment, personal injury, boundary disputes, leasehold issues, stuff like that.
So your rule is of thumb, if it's an owner-occupier, then almost 100% chance that he will have.
They'll have an insurance policy. It's whether or not they've got LEI cover. It's whether or not they've paid the extra 20 quid.
Okay.
Because people sometimes try to minimise their costs, and it's only when they get sacked and they realise they're going to have to go and spend quite a few £100s on a solicitor that they then think, oh, I should have paid that extra money. And in fact, I've had a few clients that haven't had LEI that have subsequently gone and got it, just in case they have problems in the future. Unfortunately, had to learn. They've had to learn the hard way with that.
And a very specific question: when you started LEI cases, did you have to tell your insurance, and did you have to pay a higher amount, or what's the sort of consequence in terms of?
I think the first time we did a case, we had to increase our insurance cover, but I think our insurance cover is pretty high now, so it generally covers most. It would cover most LEI insurance expectations.
And will you talk to us as to what you present to the insurers and how, because we would, for instance, we record our time, but we probably don't record it the way the insurers will want it to be recorded.
Well, we sort of look at that case recording and stuff like that as well. But it is something, yeah. I mean, you learn. You when you work on fixed fee basis, or if you do not for profit and you're doing fixed fee or no fee kind of, because no one's actually paying you, then yeah, there is a tendency not to record every telephone call and so on and so forth.
Yeah, that I understand.
You just have to get into the habit of doing that.
And insurers won't, I mean, you've already told
Yeah,
us insurers won't
you'll
pay.
be doing yourself out money if you don't. that's the bottom line, basically. You've got to actually, and it is about improving your case management systems in order to basically record every piece of work you do.
So in terms of money, so say for example you run a case all the way to the hearing, and then you'd go through like drafting your bill, going to the cost drafts. How much are you talking about?
Well, we're going to come on to after we are dealing with cost drafts and everything, cost draftsman and all that stuff after throughout the day.
Yeah.
So what we're doing is running through the life of the case at the moment. So
like I was just wondering, in terms of like employing someone to do, like I'm funded through Trust for London. It's only for 2 years. Obviously, our organisation's looking for like how to develop the role, and obviously this would be a great way of doing it. And I'm just thinking, you know, in terms of like funding someone, have you found that this is sufficient to fund a role, or do you still need other funding to supplement?
Well, certainly one of our solicitors, our senior solicitors post is not specifically funded from any pot of money, and it comes from a combination of pots, including things like this. And as I said, it's about increasing awareness as well, because obviously once if you do like 3 or 4 cases in a year, then you could potentially fund a solicitor, depending on what you actually get at the end of it and so on. But you could potentially fund a post. So even if you funded, say, 3 solicitors, if you funded 4 cases, you could probably fund somebody for like 3 to 4 days a week, and they're going to do much more than 4 cases within a not-for-profit context. So it is, although it can be a bit of a hassle, as I said, my experience is that all funders, like most funders, I mean Trust for London are actually quite a very good funder, but most funders, like local authority funding, legal aid funding, it's a hassle. You're having to report to local authority every quarter, like with evaluations and breakdowns of who you've seen and outcomes and so on and so forth. It's a hassle. And you just accept that as part and parcel. And I think the not-for-profit sector needs to think to itself, well, actually, I seem to be willing to accept that hassle. So, yes, doing insurance casework can be a bit of a hassle, but in some ways it's no different from the hassle that you might have from other sources of funding. It's just a different hassle.
I've done legal aid work, and I know
more.
It's anti-funding as well.
Yeah.
So you get money from the council, and they want so much for the money they give you. And they want you to spend every penny exactly as they specify, and that can be quite frustrating. Whereas if you get money from legal expenses insurance work, it's funding, and then you can spend it on whatever you want. And, sorry.
I just had a sort of broad question, which in my context is very important actually. In your experience, what exactly is the most challenging thing in introducing this way of this income source? Is it the businessifying operations, make it run like a private legal firm, or governance issues, or dealing with users? What would you say is the most that's
I think one of the things that was for us was probably adapting our case management systems to maximise on what we could charge for. That was probably the most challenging thing. We were pretty open to, I suppose as an organisation, we were always quite open to looking at alternative sources of funding, but definitely I think adapting our case management systems and also looking at how we can maximise our costs. Like most people in the not-for-profit sector, we just weren't used to.
That's what I was thinking. That's what I was thinking.
Should be.
Apparently it was upheld, and I think she got some money. But it was resolved in her favour. You know what, we need to call this down here and obviously we just did it, wasn't it? Yeah. It was
Okay, Jenny's coming round with the next exercise.
I'm interested to see how they decided to reimburse her for it. Because when we were in we do that all of the time, and she said they did it. I don't know if it's possible, but thank you.
Okay, in your information packs you will find 3 case studies, which are FSO case studies. That's right, isn't it? Is it? So is it 4 case studies? Okay, so the FSO officer Harriet McCarthy has written these 3 decisions for Mrs S, Mr D and Mr A. What you will need to do is have a look at those case studies first. Is that right? Or do you need to read the... Yeah, have a look at the case studies quickly. Have a look at them first. Okay, everybody, I'm assuming you've all had a good chance to read through the case studies. Scenario aside, the outcome in terms of Tom approaching his insurance provider is, as I said, is often to be expected.
Yeah.
So in the first instance, what would you do? The first thing you'd ask Tom for?
Copy of the decision.
Yeah, indeed.
And his insurance as well, possibly.
Copy of his insurance policy.
And also, what stage are we as well?
So you've got, presumably, you asked for a copy of the insurance policy. Just if you haven't already got a copy, I'm presuming you probably would have. But you would definitely want a copy of the decision letter. I think sometimes the insurance companies will provide a decision on the phone first, and then you have to hassle them for a copy of the letter. So that might be incorporated in. So what we've got now is, I mean, there are obviously all the issues about opinions and everything, but before we come on to that, Jenny's going to come round with the next questions. Okay, so Tom's approached you, he's your client. He has a potential unfair dismissal and sexual harassment claim. And he's had various problems with his insurance provider. So I think we've pretty much covered matters in the first question in terms of obtaining the decision letter. So moving on to the second exercise, how would you advise Tom to proceed?
Appeal it with the solicitor's advice, potentially, to begin with. Appeal the decision of,
the insurance.
The insurance. Sorry, that's what I meant.
Okay, so I think it might be, in order to get people to actually talk about this, because I noticed that lots of people are sitting there very quietly, what I'm going to say is if groups 1 and 3 can look at what other considerations are there and feedback a few points each, and also groups 2 and 4 could deal with how would you advise Tom to proceed, and again feedback a few points each. Otherwise, I'm going to have people sitting there silently. Okay. everybody. I'm going to get some feedback from everyone now because we're running out of time. So, those of you that I asked to look at question 2, I think that was group 1 and 3, wasn't it?
No,
2 and 4, was it? Okay, fine. Okay, so could group 2 give me some matters in terms of how they'd advise Tom to proceed?
Shall I? So obviously we want to appeal the decision. At the moment it's going to have to largely be based on Tom's instructions. And we'd want to address those 2 points that they've included in their decision letter. So the lack of evidence of sexual harassment and the fact that Tom was on duty at the time of theft. So we were talking about using those 3 bullet points of information to say, actually, based on his instructions, it does have that 51% or more chance because we've got witnesses of the sexual harassment itself. We felt the Valentine's card may be a little bit tenuous, but you sort of put in what evidence we've got at this stage. And so then in terms of the fact that Tom was on duty at the time of the theft, that in itself isn't conclusive in terms of an unfair dismissal case. So you want to look at what investigation, for instance, has the employer done. And then the last point we were looking at, which from the 2 bullet points there they don't seem to have considered, is in terms of so in relation to the unfair dismissal element, the length of his service. The fact he's been there for 8 years with an unblemished record seems a little bit unlikely that he would then put that at jeopardy to nick some livestock. So those are the kind of grounds that we want to raise with them.
Great, that's great. I'm stopping you because I want to know what group 4 have got to say.
Is it on points on the
This is on questions. How would you advise Tom to proceed?
So we basically said the same thing. We would take full instructions. But we'd want to know whether when he approached the insurance company, whether he told them all of this. And if he didn't, obviously give them all this information. Also ask find out the qualification of the solicitor who made the decision, so that you can then consider that as well, and then tell him obviously that gathering evidence, getting a second opinion would be the best way to go about challenging the insurance company's decision.
Okay.
I think we would also probably want to, as the first group said, make sure given the amount of complexity there, you'd probably want to specify what you thought the chances of success was to put the insurance company a little bit more at ease. I don't know.
Okay. I know I'm aware that question 3 kind of does have an overlap. So
Yes.
what I'm going to do is, before I come back with any feedback, I'd like group 1 to give me some feedback in terms of what other considerations there might be as well in the matter to take into consideration.
We thought a bit about what Tom's current situation is. So, has he got any money at all? Has he got a job? Could he? So basically, looking at a schedule of, a very initial schedule of loss. Was there likely to be written evidence that would support the claim? So, Mrs. Hughes, is she still around? Would she provide a written statement? How much further, more concrete evidence could you get? Whether there'd been a grievance, so when Mr. Crawley didn't take it very seriously, was there a meeting? Were there any notes of the meeting? Was there at least a diary date? Or was that just an ad hoc conversation? But what else existed?
And how much the claim is worth?
Yes.
Give you a point.
And group 3?
All right.
Adding on to other considerations?
I think we've looked at it about
time limits.
we need to consider about time limits because we
Absolutely.
might we don't want to be negligent. And the other bit as well is just it's about the looking at the insurance standard terms of appointment as well. Whether the insurance limits, the fees on all that stuff. So we will look at it, whether they put onerous preconditions, because clearly he is likely to be allowed to appoint his own solicitor because of the sexual harassment case claim he has under the regulations. So whether this insurance, then they're going to put up like ridiculous indemnity requirements, all that stuff. So we need to look at it, and possibly, if there are that kind of conditions, he might need to consider to put that together with his appeal rather than putting it again.
Okay. But why do you say that? Because it's a sexual harassment claim, he will obviously be able to appoint his own solicitor.
Yes.
So I think he will be able to, because
He
it's
will
not
be.
just 81 anyway. But I don't see
No.
why
What we said is the insurance. They will concede that he will appoint his own solicitor. But what they would do is just they might
For the
require
obstacles that they might.
the solicitor who's going to take his case has to have 10 million indemnity
Yeah, so
insurance or
for the
national.
potential for the obstacle, they might stipulate.
because of the
So-
sexual harassment element?
No, just to avoid
I think
the
there
case
was
going
a-
out
so-
to independent solicitors rather than to their panel. So you just
I don't think it's lodged the 81 at this stage, anyway.
No.
That's later.
Yeah.
So before the proceedings.
So,
So
but the
they can have
fact, I mean,
choice.
do we need to be aware that if there is a
Okay.
sexual harassment element, there's different rules? Or?
It's not cut and dry, but it's just about, because if you looked at the decisions, you will see that what the Ombudsman tends to do is look at the individual circumstances of each case. So where you have something like sexual harassment or maybe a complex disclosure case, something along those lines, because of the complexity, it might well be that you could justify the client instructing you at an earlier stage, presuming that you have the qualifications and the necessary experience to deal with that. But in terms of the questions 2 and questions 3, most of you have covered the various elements that you might need to consider, but one of the things that you would obviously be thinking about in the first instance is that Tom has obviously approached his insurance company as an unrepresented person, because if you look at the facts here, he's come to you after the insurance company have refused to fund his case. So what we'd be wanting to know from Tom is exactly what did he tell the insurance company? Did he actually tell them about that he wanted to bring a claim for sexual harassment, for victimisation, and for unfair dismissal, or did he just give them a broad sort of like, coverage over the phone? Because what we'd want to know is exactly what the insurance company understood his claim to be and exactly what the insurance company are refusing to fund. So that's obviously one of the things we'd need some clarification on. And we'd also need to know what the appeal deadlines are in terms of bringing an appeal, obviously. And I think in a case like this where there is a sexual harassment element because of the discrimination element, we would probably be wanting to get a barrister's opinion. So we would be wanting to negotiate with the insurance provider about covering the cost of that, particularly if we've taken a view that the case does, on the basis of initial instructions, have a reasonable prospect of success. And as some of you have also mentioned, the case does appear to have some witnesses, and so consequently it does appear to have some evidence to support it. And as you've also mentioned, that we want to know what sort of investigation is being carried out. Why has Tom just been dismissed, given that he's got an unblemished record? And in the circumstances, it definitely screams out unfair dismissal or potential unfair dismissal, if not sexual harassment. So we would at least want to explore that. In terms of other considerations, there's obviously the Employment Tribunal deadline, as has already been referenced here, and my view is that by the time the insurance company come back with a decision, given that the acts of sexual harassment will have preceded the dismissal in any case, it might well be that the claim will have been filed. But on a pre-claim basis, Tom's come and instructed you, and you've agreed to assist Tom to basically challenge his insurance company, and also while you're challenging the insurance decision, you're also running his case for him. So at this point in time, it's arguable that you can set your hourly rate in accordance with what you want to set it at, and that if after the insurance company agree to fund his claim, they agree to fund it on the basis of their hourly rate, there's at least an argument that would run that from the time of Tom instructing you to the time the appeal is upheld, that there's grounds to support the insurance company funding you at your own hourly rate. if it's set at a reasonable level. And the case law or the cases within the Ombudsman cases certainly seem to support that, particularly if the rate is set in accordance with like what considered to be sort of like court rates and so on in terms of.
And just on this particular question, where would we go an employment case? What kind of rate would we look at?
Sorry.
On this particular question, the issue, like we would want to set up our own hourly rate, which may not be the £100 per hour.
Yeah.
Well,
this is again, this is a decision for those of you with charging wings, or for those of you who do charge work, or even if you don't charge for work. It's a case for you to actually potentially look at what, like, in terms of when courts assess costs in cases where a client or where somebody takes a case to the court to assess costs. Courts have a basic standard that they will use in terms of what they consider to be reasonable, and if you use that, there's no reason why that shouldn't be supported by or upheld by the Ombudsman. And certainly during the appeal process, because at that point the case is in dispute, and you haven't signed any paperwork at that point with the insurance provider to say you will act under their terms. But what you're arguing is you've had to protect your client's position, and if you hadn't filed the ET1, then you wouldn't have a claim. So what else is supposed to happen? So that might be a separate matter that you might need to take to the Ombudsman.
And in your experience, where would typically would you fix your hourly rate?
That's again, that is a decision for you based on things like your post-qualified experience and also on your actual level of specialism in terms of the area at hand. So if you particularly have a specialism, say in disability discrimination or in sexual harassment claims, as is the case here, you've got a specialism in that type of claim. You can potentially argue that your rate should be set at a higher rate.
And in your personal experience, have you had cases like that where
we've had cases where we have actually negotiated a higher rate? Yes.
For that
specifically for being paid for pre-claim, not pre-claim, but from in terms of earlier than when the paperwork was signed with the insurance company negotiating a higher rate.
But then did that mean you had to reduce that rate once you signed the terms and conditions, or it was negotiated for the whole case? Do you understand my?
Yes, I do understand. I think with what's going to happen with the case is a cost draftsman is always going to come in and they're going to say that certain elements of the case does not need to be done by someone that's highly specialised. And so when it comes to, say, drafting submissions, if you drafted your own submissions or drafting lists of key issues and key facts and stuff like that, then you could argue that you need to be doing that. When it comes to preparing the trial bundle, on the other hand, you don't need to be doing that. So you're never going to justify like a higher rate for stuff that can be handed on to somebody with less experience. So the rate will always potentially vary throughout the life of the case for certain types of, depending on the actual work that's being done.
Just so that we have a sort of practical, the kind of high rate that you had, is that £200 or is that?
Well, as I said, it would depend again on your PQE and
I understand,
the level of
but
specialism.
So
for example,
would that be
the
up to
Ombudsman case, it was set at £192 plus VAT
and that was
in that particular case, and that was acceptable because of the level of experience, and also it was that the client had to instruct from the point before. Before which had already approached the insurance company, but they hadn't funded, and then from there until the point of funding. So that was considered to be completely reasonable in the circumstances.
But what if, I know what you were saying about drafting your submissions and doing the trial bundle, but if I'd be the only one that's doing it, in that case...
you cannot expect an insurance company to give you £200 an hour for putting together a trial bundle. What will happen is when it goes to the cost draftsman will say, we are not paying that. There is no need for somebody of that level of specialism to be doing that sort of...
But they then just reduce
they would reduce it. Yeah.
Okay, and we can't say where we've got no one else.
Well, that's tough. Well, it's tough. I mean, that's basically the bottom line on that one. Some of them would just pay a fixed fee. I mean, this is one of the things about the fixed fee is that if you're just getting £100 an hour, it might well be the case that you can justify everything you do for that fee. You can say, well, you pay a fixed fee. You never told me that I should be instructing somebody at a lower level. But if you're negotiating a higher rate, then it's going to, it's going to be about exactly how you can justify that. So in addition to that, so saying fixing your hourly rate, so are you doing it on a pro bono, potentially pro bono basis, hourly rate basis, based on whether the insurer actually pays? And so that obviously feeds into the date you're actually instructed. And then yes, we come to things like that have already been mentioned, standard terms of appointment, and Tom's current financial situation as well. So finally, the last question. So yes, you've done all this work, they've agreed to fund you, 50 quid an hour. What do you do?
Well, would you find out what they pay their hands?
Again, that's exactly what we would do, and the chances are is they're paying them more than £50 an hour. And even if they're not, I would say, in accordance with the cases, that unless they've actually set out in the insurance, in the policyholders' policy that that's what they pay, then they cannot justify that. They will not be able to get away with paying that level of fee. But it can very easily be negotiated upwards to something that.
If you've got a case management system, because the one I've got doesn't allow for fees, could you then say certain work, like the copying and the basic administration, could you put that in yourself at a lower rate? Or could you have variation?
We're going to deal with costs after lunch.
Okay.
Just another weird question. You don't. I know you said before that you don't charge clients. You don't have a charging wing.
We don't have a charging wing.
So in the but you said that
we managed to get higher rates.
I know. So but I mean, if we're the same, we don't have a charging wing. So how can we say, well, actually, from the moment you instruct us, we're going to say that our hourly rate is whatever, 150.
Yeah, well, we can. I mean, what we would say to them is, well, we're not. If they try to, I mean, they generally don't come back and say you're a charity, therefore you can't charge that sort of money. We've not really had that type of argument. What they're interested in knowing are things like what our PQE is, whether we're qualified solicitors, our PQE. What we specialise in and what our insurance covers us to do. Those are the questions they're asking. They're not saying to us, well, what do you, they generally don't, because they don't deal with not-for-profit sector very much, you see, so they're not trying to make the case that we should be doing the work for free or for
and they don't say, well, if we hadn't agreed in the end to reimburse you, you wouldn't have charged this particular.
Well, they wouldn't necessarily. Well, that's none of their business, to be honest with you. Because what we're doing is we might be agreeing to do it on a pro bono basis, and that pro bono basis is that if we can get funding for the work, we expect to be paid. And if we can't get funding for the work, we'll write it off.
Okay. And it doesn't necessarily need to be clear in your client care letter because they won't need to see it.
So they might want to see it, so then you just have to think about how you word it. But ultimately, there are lots of reasons. If they were to argue with you, you could basically make a point about the fact that we've taken this case on the basis that we think that it does have a reasonable prospect of success. You've agreed with us that it does. We wouldn't normally see this client because it might be that they live outside your catchment, or it might be that their income is too high to actually be seen by us. So this is actually chargeable work. We are doing this case at financial loss, and we expect to be reimbursed for it. It's as simple as that. Okay, it's lunchtime now.
Yeah.
It's lunch here.
Yes.
It's there. Brilliant. Okay. Okay, just a few more things to touch on that we didn't get a chance to cover before lunch. So. We've already discussed late notification, and as I've already said, the usual expectation is that the claimant or the policyholder has contacted the insurance provider within 180 days, and that can sometimes be less. So it's obviously important that the policyholder or you check the terms of the policy, and that will be in their policy. Obviously, it's not a case in employment, generally not a case in employment tribunal proceedings, unless a client comes to you with a case that's already running in the tribunal and it turns out that they've got LEI and they didn't realise it, or they've disclosed it late. That said, the FSO's position on late notification is that in itself it should not result in a rejection unless it can be justified for other reasons. And that will be things like time bars, preservation of evidence, witness recall. So if somebody's coming like 3 years later, well, that's obviously going to be a problem. But in an employment tribunal claim, it's unlikely to be a problem unless the claim is out of time. So there shouldn't really be a reason for the insurance provider to refuse to fund the claim just on that basis alone. They would have to really back it up with other reasons.
Sorry, I know you covered that there. That 180, is it from the date of complaint?
I would presume it's from the date of the complaint. That would be my presumption. But it changes from policy to policy. It does change from policy to policy. So it's always something that the policy holder would need to check in terms of the terms. So some of the policies are actually for less and some of them are for more. There's not like an industry standard or anything like that. So we put in 180 days because on the policies we reviewed, we noticed that seems to come up the most.
No, because I've got a client coming tomorrow to see me. Potentially we might be doing it on this. And I'm just worried that we might be more than 180.
Okay, I think it can be argued because my view is and the FSO's position is very much that unless there are other grounds to refuse it, it shouldn't be refused on that ground alone. Okay.
And Elizabeth, what's your experience of arguing with the FSO? I mean, how time consuming is it?
In terms of the late notification, I don't think it's been a problem for us so far because of the nature of employment tribunal claims. Most of the time, this hasn't been an issue. We've just raised it. I mean, I think it's probably more of an issue in things like personal injury claims, but we're just raising it in the event that somebody does come to see you and their case is already at the tribunal.
Yeah.
And whereby 180 days might well have passed.
And more generally, when you keep telling us, well, you should, this shouldn't be a problem, or you should write to the FSO about it. How, in practice, how time consuming?
Okay, what you do, I'll hear what you're saying. Sorry. Well, what normally happens is you would need to complain, and I have complained to the insurance provider about whatever it happens to be, whether it be late notification, fees, whatever it happens to be that you're making the complaint about. And then if they don't uphold your complaint, then you can go to the FSO. I've not got to the stage where I've had to go to the FSO because most of the time they will uphold, they will just deal with the complaint or they'll go back to you and negotiate. Okay. But as I said, late notification specifically, we've not had a problem with it. I've included it just in case it is a problem for some people in the future, but it's not something we specifically have a problem with. Okay, so finally, FSO complaints. Here we go. These are the numbers. And they make up 2% of issues dealt with by the Financial Ombudsman. So that's actually, to be honest, given that the Financial Ombudsman covers quite a lot of matters, including issues with banks and all sorts of things, I think that's quite high.
And is that 2% of 707?
No, that's 707.
That's the LEI case.
Specifically to do with LEI.
Do you have an idea of the time frame they take to respond to a complaint? Or?
Well, sorry, can I interject? Because I do consumer,
okay.
And I deal with the Financial Ombudsman Authority, Financial Ombudsman, and up to 12 months.
Oh.
So.
But here again, I mean, with the issue of with the issue of getting your case, the sorts of issues you're probably going to end up having to go to the FSO about will be whether you're funded before you sign the paperwork with them, whether you can pick up the funding for that, whether you can pick up a higher fee than the fee that they set, which is likely to be around £110 an hour, what they'll pay you at the end after they've assessed your bill of costs. Those are the sorts of things you go to quite often find yourself going to the FSO about. It might be that you get somebody that does come in, they're more than 188 days out, and then it might just be a case of saying to them, well, I can't take your case on this basis because it's going to take too long if it has to go to the FSO. But my view is that most of the time the insurance company, once you negotiate with them, will listen to you, and certainly if you complain. then they will deal with it. But the sort of things, if you did have to go to the FSO, they tend to be more about hourly rates and stuff like that. Okay. And yeah, I know it can take up to a year because we also do some consumer stuff as well on our evening sessions. Okay. What's the next one? Okay. Okay, so this is a base in terms of common issues. This is just a summary of the things that we'll be covering this afternoon. Keeping a detailed schedule of costs from the beginning of the case. So maximising on chargeable work. And this is as much about recording and how you sort of detail the work you do as it is about what work you pick up on. So appropriate use of senior junior staff in case management, and if you've got a good case management system, it really helps. And then file management and review, and SRA compliance. In terms of file management and review, we're going to come on to that. Just briefly, most insurance providers will expect you to have a file set out in a specific format, and it's likely to be, even if you've got an electronic case management system, they're going to want a paper version of the file. So you will generally be running that, as well as if you use an electronic system like we do, you'll probably have a paper file at the same time, because they will want things set out in a specific way for purposes of review and assessment. Okay, maximising on chargeable work. If you work on a fixed fee, or if you work on a no-fee basis, keeping abreast of every scrap of work you do is something that I certainly found like didn't come naturally to me. Because I'm so used to just dealing with my cases and not really having to make scrupulous notes of everything that I do. That I possibly initially forgot to claim on certain things. And I think the thing to be aware of is as soon as someone walks through the door that's got ODI insurance, even if you haven't been to the insurance company yet, it's a good idea to start keeping a very detailed schedule of everything you do. Outgoing correspondence, as most of you will know, I think it's the same with legal aid work. Outgoing correspondence is paid for, incoming correspondence isn't paid for. Take the initiative.
But you can get paid for considering the income.
We're coming on to
that.
that. Yeah.
But with legal aid anyway, but might be different.
We're coming on to that. And I mean, I also take a view that, I think sometimes there's a tendency, if you do things in a certain way, to send a very long email in the first instance about something, because then you've covered everything. But sometimes it's better to split things up into sort of little packets of information as you go, because you can charge more. Right, using terms insurers accept. So it's a good idea. A lot of insurers will give you their terms in terms of the costs and stuff like that. So you need to really review those and establish exactly what they will accept in terms of your chargeable work and what they won't accept. Because otherwise you might be submitting a bill of cost to them, and they're going to immediately argue that they don't have to pay for half of it because you basically set it out in a way that means that they can argue it away. So a lot of it's about setting it out in a way that they can't argue it away. So yes, there's consideration, but there might be better ways of dealing with that. Okay. So consider an expected time frame insurers will pay. So this is all. Okay, yeah, sorry, pardon me, I was thinking it's about exactly when they pay, but yes, they generally have an expectation that certain things are done within a specific time frame. So in terms of maybe an advice letter or a trial bundle or a list of issues, they have an idea about how long those things take. Some of those things, in my experience, take me less time than they'll pay for. But then there's other work that they won't cover. So the consideration will come into the what they will cover. because it's about maximising your costs, and frankly you do consider, but if you packeted off consideration of something for an hour and then drafting a list of issues for half an hour, because it doesn't take that long because you can cut and paste from your previous list, you might want to just argue that it's taken you an hour to draft your list of issues because of the consideration involved, and they'll probably pay an hour for drafting a list of issues and facts, but they won't pay an hour for consideration necessarily, so that's something to bear in mind.
So where do you get your info from?
You get the info, I mean, it's generally, you will get the info in the terms that they provide you with. They will quite often set out what they pay for and what they won't pay for.
Okay, so they'll quite often set out a list of issue 1 hour.
Yeah, and not all insurance companies will do this, and so you'll have some that will just literally just don't give you any guidance whatsoever. So it's a very easy form to sign off at the beginning in terms of very simple, straightforward terms, and that can be quite attractive in some ways, whereas the longer terms and conditions look a bit like onerous, but you do at least know exactly what's expected of you. And again, engaging correct levels of staff to undertake tasks.
So, we have an example letter from an insurance company for the last part where they've agreed to pay the same rate for, I don't think it's actually in your packs yet, I've got it here. They've agreed to pay for a trainee to prepare the bundle at the same hourly rate, but then they said that that would be the only bit that they pay at that rate for a trainee. So that had to be agreed with them before.
And I think the reason why we did that in that case is because the fact that trainee is technically not a solicitor, so we didn't want them to argue that away in the final bill of costs. So it's about getting consent from them. Okay, so when you get your, in the terms of reference or the terms of agreement that you sign, it will set out exactly how you're supposed to submit the file to the insurer and what required format there is with the bill of costs. And I mean, it goes without saying, it's just basically something you have to do. It's a bit of a pain because they'll have they often set out their files differently from how I would set out my file, but it will be things like, you know, my way of doing it might be different, but they might have things like medical evidence, expert opinions, court paperwork, and various other things kind of segmented off. It's just a simple case of doing that again from the very beginning.
We have a cost draftsman that deals with our legal aid work because we have hours in legal aid. Would they do something like this, do you think? Or is that something I just have to find out? Is it worth giving the file to our own cost draftsman?
Again, if it's possible to give it to your own cost draftsman. So the insurer usually refers it to their cost draftsman. Now, I know that from dealing with a case where the case was referred, so ultimately there was a panel solicitor acted and we acted as well, so two firms acted on this particular case. The panel firm actually did instruct their own draftsman to deal with the case and or to deal with their part of the assessment, and so it's worth again, it's something that you would talk to the provider about whether or not it's possible to refer it to your own cost drafts person or not, or whether they would specifically want to refer it to their own firm. If there's a dispute, I would presume that it would be possible to maybe get your own cost drafts person to have a look at it, but I would say that if you can refer it to your own, if you've already got a cost drafts person who gets to do work for you, if you could possibly refer the file to them, it would probably be preferable if the insurance provider will allow for that. Okay. Okay, so we're going to split you into, I think, should we do it into two sets of two? Or 2 groups? Got a smaller group this time, haven't we? 6 people as well. Okay. Right, we've got next, I'm going to split you into 2 sets of 2 groups. So, Barbara, if you're 1 and you're 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, and then if the ones can, you 3 ones, how many ones have we got?
4 ones.
So we've got 4 ones. No, we've got 1, 2, 3, 4.
1, 2,
We've got 6 ones, okay?
and 1, I think.
Yeah, we've got 6 ones. So 3 of you could kind of pair up.
3 ones.
3.
Alright, 3 ones people. Alright.
Okay, what we're going to do, I'm gonna
Yeah.
this is probably easier.
3 ones, did you say?
If you could like maybe come round here and sit over here,
And then the 3 ones sit here.
and then the other 3 can be there, and then the groups of 2, there's 5 of you. If 2 of you could pair up, and then the other 3 could also form a group. Okay. Basically, what I want are 4 small groups, and so you just work out how you're doing it. But what I'm trying to stop is people from the same organisation working together. Okay, so what you should have in front of you is, we're using NAS's standard account form, okay? If you are, who are my group 1s? Okay, what you're going to do is you're going to look through this and you're going to maximise in terms of what you think you can charge for. So you might be rephrasing some of the items in order to try to ensure that you get paid for them. My group 2s are going to be cost draft persons, and they're going to go through it and they're going to try to eliminate as much as they think they can possibly get away with. Okay?
So it's not anything.
I think group 2 is probably the most fun task. Group 1, you've really got to try to maximise on your costs. So what I'm going to come round and give you now is, in connection with that same costs, bill of costs, I'm going to come and give you the costing report as the insurance providers initially assessed it.
Oh my goodness. I'm joking.
So you will see.
Okay, it was 10 grand.
This has been.
Oh, that's you.
Is that what it was? I didn't see what it was.
So you're looking for.
You guys that were being cost draft people, have you actually sort of had an idea about what you could get away with taking off? You have a look at this and see if you've been harsh enough.
Oh God. So look.
Have you got one more?
Actually billing for 6,700 and something, yeah? And they in the end awarded 8,000 something. I mean,
Okay.
obviously.
Take notice of this. If I could just point out, on the front of the cost report, in true insurance company style, they screwed up all the figures, and these ones at the very front make no sense to us whatsoever. It's the ones that are on page 2 that are the summary costs that you need to review. And you can see there's quite a substantial difference.
1,008. Oh my God.
And what I want you to do is look through, have a look through that report and look at what they've taken off.
So it's basic
Okay.
That's again.
The profit tax.
So don't worry, it was challenged, and we've got what we finally agreed. But
But you take off the 360. I bet they didn't take the 360.
so I'll give you 5 minutes to look at that, but do have a look at the detail of exactly what they've taken, what they've agreed to pay, and what they haven't agreed to pay. Because it's quite revealing,
Is it?
and in terms of the way
Alright, that's
the we've actually they described the work.
The obtaining quotes, and you should have the obtaining quotes.
Obviously, if the insurance provider has decided that they're already going to fund it, there's a likelihood that it has got reasonable merit, otherwise they wouldn't have agreed to fund it. But just small things like that. I mean, I've had problems with being paid where there was another firm acting. So the client's case was that there was a panel solicitor, and then there was me and a panel solicitor, and basically the panel solicitors didn't bother to refer the file to cost draft person for ages, which delayed us being paid. Because obviously from the insurer's perspective, they wanted to see exactly how much had been eaten out of both budgets in terms of so that they weren't ended up paying, because they wouldn't pay one without the other, simply because they wanted to make sure that it didn't exceed the maximum amount. So these can be issues. It's always worth trying to establish or trying to pick up as much information on that, just in terms of not so much just the case, but the LEI history and so on as well.
Would it be the same if it wasn't a panel solicitor, but
yes,
another?
Yes, it would be exactly the same.
Okay.
I mean, at the end of the day, if the client wants to, there might be various reasons why that they don't want to continue with their current provider. And so, provided the insurance company are happy for the client to transfer the file to another solicitor of their choice, and obviously that would be something. I mean, the insurance company aren't going to sign, if they're providing you with their terms of agreement, then they're agreeing for you to act for the client, ultimately. I think, yeah, where you've got a client that might have instructed 3 or 4 solicitors, we've not had this problem before. But yeah, you might not want to pick up their phone because obviously the alarm bells and then start to ring and you can start thinking, why is this person going from one provider to another?
Especially if they're doing them all along the line as well.
But that's not really the problem. It's more about that it is possible, given that some clients a case might initially start out with panel solicitors, it is possible that you will be picking up a file from another solicitor. And it's just worth bearing in mind some of the issues that might raise. Okay, so we've dealt with ongoing problems with cost draftsmen. Is there anything else you have to add on that point? Disputes on dates of retainer. Okay, I've had this as well. Again, this might be an issue where the file transfers between one solicitor and another solicitor in terms of the actual date that your retainer starts and the date that your retainer ends. It also might be an issue where an appeal's been in process, where clients instructed you or they've gone to the insurance company's refused to act and then they've overturned on appeal. Obviously there's going to be disputes about the date of the retainer in cases like that. So so these are matters again that you might need to deal with. The dates of retainer cases quite often there are financial ombudsman decisions on those, and they generally are quite supportive. But that said, it's sometimes a good idea to pick up the phone to the insurance provider and say, what is the date you've agreed to pay me from? Best not to make any presumptions because, you know, it might just be easier to deal with it earlier on than later on.
In terms of if they've reached the limit or
Okay, yeah, and again, this is again requesting the schedule of costs from the other solicitor just to see what they've claimed so far. And obviously, they might not get paid that much, but it's useful to know exactly how the claim has gone. Particularly if you're coming towards the end of the claim, somebody comes to you, it's definitely worth picking that up because you might find that they've exhausted what will be paid. Delays in payment. You've done all this work, they've agreed your fee. Payment just hasn't come through. It's just a case of chasing it up and complaining if need be. There's not really very much more. And again, where you've got 2 solicitors acting, this is or where one solicitor acts and then another solicitor acts. This is likely to be the occasion when there will be a delay in payment because the other solicitor might not have submitted their file.
What's the longest you've ever had to wait?
Sorry?
What's the longest you've ever had to wait?
Over a year.
Over a year?
Yeah.
Oh no.
That was
after submission.
You don't ask for an interest.
That was actually a case with where another solicitor was instructed in that case. So it was a particularly difficult client, and I was quite glad to see. I was quite happy for them to instruct. And I mean, they basically went from me to another firm, and the other firm. So obviously there was a life history of the case after that. But then the other firm didn't submit their bill of costs and the file for some 6 months or so after the case settled, and that caused a delay in our bill of costs being assessed.
So generally, if it's not that in those circumstances and you've completed
If
the
it's
case,
just one, if you've taken the case from beginning to end,
how long
that's
that
not
process?
likely to be a problem, because what the delays are usually in terms of negotiating with the cost draftsman in terms of what you will actually be paid for.
Okay.
And obviously you're quite happy for that delay because you want to be paid, you want to maximise your payment. And then once the payment's been agreed, it's generally, you should be paid within a couple of months.
Okay.
That's right, isn't it?
Yeah, we did have one problem where they kept saying that our bank details didn't work. So then they were going to have to pay us by cheque instead. And then they kept postponing posting the cheque, but they did eventually pay.
Okay, so yeah, but yeah, I mean, I think once you've gone past all that, you'll get, once you've passed all the other problems that might arise along the way, you should be paid. I think it's just in terms of picking up a file from another solicitor or passing the file on to another solicitor. There might be problems in terms of payment, delays in payment, because ultimately you're not the only person that's got to have control of that file. So
It's a good question. In a likely case, or maybe likely, that the other solicitor that you either took it from or passed it on to dies, goes bust, something horrible happens, then building stands in flames, these things happen. Will that affect your payment?
it shouldn't. No, I mean we've well obviously I've had a case where I've had to submit the file and the bill of costs again. But it's generally we've been paid. So where there are problems, it's not really our problem if there's a problem with another solicitor, because it's not we've not got an agreement with that solicitor. We're not subcontracting them to do the work for us or anything like that, and they're not subcontracting us. Our agreement's been with the insurance provider, and so provided we fulfil the terms of that agreement and we're not in breach of that agreement, there's no reason why we shouldn't be paid.
And will council chambers sort of see red if you tell them what?
Yeah, I mean, most of the time we've been quite clear with them from the very start that this is an insurance-funded case and that we cannot pay you until
we receive
payment, and that most of the time they will accept that.
Slightly different. I've got a case where the case has been launched. It's not under the insurance, but now she's going to bring another claim, which is likely to be added to the other one. Most probably she's going to launch a fresh claim. Now, when you join these two cases, what would they say the insurance? Do you think?
One of them's covered by insurance and the other isn't.
Yeah.
Okay. I would say it's probably wise to negotiate with them at an early stage in terms of what they're going to cover, because obviously their cases have got to be reviewed together.
Yeah, I mean the client should have done everything by herself.
Yeah.
But
so when they joined,
she did mention to me that I do have this insurance now. When we looked at it, hold on, this is quite. Whole thing happened quite before she took the insurance, but the second incident that she's now intending to bring a claim for happened after she took the insurance.
Okay, has she approached the insurance company yet?
I don't know.
Okay, so one of the first things they're probably going to try and argue is they're probably going to try and link it to the other acts and say.
Yeah, that's right.
Is that what you're asking about?
Yeah, that's why I'm a bit worried that they might not try to say like, no, that this is just a continuous act and it's not the same thing. So.
Yeah, I mean, it is a sort of thing you might need an opinion on, really, I think, because it sounds like, I mean, is it discrimination claim? Yeah. It's.
I mean, it's the same base of discrimination, simply same race.
Right.
And all race. It's just. I'm not confident.
Yeah, I'm from the decisions I've looked at, there are decisions where they're, that sort of cover similar things, but I think it would be, it's one of those each case on its own set of facts kind of thing. So
I mean, it's going to be very difficult for me, even if they agree to pay.
Because if one
the
act
second
is
one,
stemmed
then
from
just-
another act,
Which one? Sorry?
if one act is stemmed from another act, then it's linked, and that's going to be a problem.
Yeah.
So if it's a fresh act, that's different, I think.
I mean, it's quite. After she lodged the claim, this happened. So it's.
Yeah.
She hasn't even lodged her claim yet.
Ah, okay. Right. I think it is going to be tricky getting that, but you know, you might need to get an opinion on whether or not the acts are linked, because it's going to be about whether the acts are linked, isn't it? Because you can't get insurance after an act.
Yeah.
So if, for example,
But the act occurred, the act she's complaining occur after she's taken the insurance.
after she's taken the insurance.
Yeah.
Okay, and they're not linked
But
to the
now-
previous acts. Because this is the question. The question is whether they're.
I mean, look, legally, I would be arguing like, this is a continuous act.
Yes.
You could argue it that way.
I think the argument would be to try and run it as, well, this would have happened regardless of whether the other acts happened. If you can make a case that this specific act that happened after the insurance was taken out would have happened regardless of whether the other acts happened or not, if you can argue that, then you might be fine. But if you can't honestly say that that act is unlikely to have, but that act wouldn't have happened independently, you might be struggling, because otherwise it might just be seen as part of the same act. But it's something that, again, it's the sort of thing that you might need to get a more, you might need to try to get the insurance provider to fund an opinion. And then you've got the issues, of course, about exactly what part of the case they'll fund. Because they might even argue, well, if it's going to be linked to a case before, then it's simply not a fresh claim, it's all linked. And even the tribunal is treating it as linked, therefore we're not going to fund it.
No, I mean, I think you could argue that because for the tribunal purposes, it's easier to discharge both of them together rather than having to.
But they're going to say that, aren't they?
Yeah, to set it clear.
I mean, I'm not sure. I take a view. It's worth picking it. It's worth a try. But yeah, I'd be interested to know what the outcome is. If you do.
I'll let you know.
Yeah, let me know. Let me know how it goes. Are there any other questions?
Yeah, I have a question. Does it work like car insurance, like in the sense that basically if an incident occurs, so this person's lodged their tribunal claim, and then say their home insurance policy or their car insurance policy is up for renewal, and can they go with another provider and that insurance will still carry on throughout the case, or if they even decide to subsequently cancel the insurance because they started the claim while they had the insurance?
Okay. I mean, you'd have to review the policyholders' terms of insurance, because what we get are the terms of agreement between us and the insurance provider. I mean, my understanding would be that once the insurer has agreed to fund something, it shouldn't be dependent on the insured person continuing their claim with that provider, because that would take away any element of choice. So my understanding would be that they should be able to move between providers after the event. But I wouldn't want to commit to that without checking what somebody's policy says.
I think the other one we were talking about as well is if someone comes to you during the disciplinary hearing.
Oh, right. Yeah, we were discussing this earlier. Someone comes to you during the they've been called for an investigation hearing, but there's not been, they don't really know the full details, and they come to you and they say, well, they suspect it's this. Should we advise them you should get insurance if you haven't got it, or is it too late? Because technically a decision to dismiss hasn't been made, neither has the
Well,
issue.
some insurance policy, or some insurers will have a bit like trade unions. They will have a waiting period, and they do that specifically to cover people sort of getting a bit wise to, oh yeah, I can smell that a problem's going to in the air at work. They've heard wind of a potential redundancy situation, so they run off and get themselves some insurance. It runs much the same. So my view is that they might struggle to be covered because
Might say 90 days.
Yeah, that's
like
right.
Yeah.
90 days or
That's
3
right.
months.
Okay.
So I don't think all of them have got it, but my view would be that if something's already started, I mean, if we got to the investigation stage and the act upon which that person may eventually be dismissed has already occurred, ultimately.
Yeah.
So,
Yes,
as
'cause
I said, there's quite often a waiting period for insurance policies.
Okay, so yeah, for the insurer, the relevant date is the actual act, not the date that you lodged the
That's
81.
right, yeah. It's the same with the trade unions. Trade unions won't also pick up on the case unless it relates to an act that happened after you got the cover from the trade union, or after you became a member, I should say, and usually 3 months will have had to have passed.
Okay, and in your experience, panel solicitors are not necessarily a good choice. I mean, if we
It's a choice for the client ultimately. It's a choice for the client ultimately who they want to instruct. What I would be careful of is a client coming to you to get all the assistance that they want to challenge an insurance provider and then taking themselves off elsewhere. Ultimately, you can't really stop them from doing that at the end of the day. But
Build some caveat and
Yeah.
rule through that.
I think so.
Yeah.
So, but normally they don't want to do that because my experience is if you challenge the insurance company in their favour, it builds up a relationship of trust and confidence in you, and then they would prefer to instruct you than the panel solicitor who initially assessed their case as having no prospect of success. So, you know.
And does it have to be a solicitor that takes on the case? Because where I work, we don't have any employment solicitors.
Right.
So our supervising solicitor isn't employment.
Okay.
Does that mean that we wouldn't be able to do this?
It generally does have to be a solicitor that takes on the case. Yes. That's usually an expectation. Or certainly a supervising solicitor that's in charge of the case. And again, it's about looking at the terms of agreement with the insurance provider, because as I previously said, some of the panel solicitors are not themselves dealing with the day-to-day work. It will quite often be paralegals that are doing a lot of the work, or litigators, but not qualified solicitors. So it's possible, but again, it's about looking at the terms of agreement.
How many non-for-profits are you aware of drawing income from this insurance?
I don't think many of them do it actually, and I think that's one of the things that because one of the reasons we've been funded is to try to sort of promote the use of LEI, or try to look at how you could develop LEI in the not-for-profit sector, because it is potentially, despite its problems, it is potentially a source of income, and it's also a source of untied income. Because any money you get from a trust or from local authority or via legal aid is always going to be specifically provided for a set purpose. Whereas if you're undertaking LEI work, then once you get that £7,000, £8,000 or whatever it is that you finally agree to settle it for, that is money that goes to the organisation and it's not tied to anything. And that can't be a bad thing. And it's also a source of income as well. And I think going forward, most not-for-profit organisations that provide advice at specialist level, if the matter falls outside the parameters of the legal aid legal help scheme, then frankly, you're going to have to find other sources of funding the work you do, and either that's going to be through setting up a charging wing, looking at developing LEI, or looking at what else can be done. I don't think pro bono work in itself is ever going to be enough, because most pro bono solicitors and barristers are not in a position to take a case on. They want to drop in and out of casework as and when it's convenient for them, or as and when they have the capacity to offer support, but they won't run a case. So it really is, the case that it's about looking for alternative sources of funding.
Obviously, I understand that you guys do it.
Yes.
This is something that you have
And it came about by accident.
championed.
It simply came about by accident. It was just a case of it started with clients coming, because we do generalist advice as well as specialist employment advice. We get people coming to us when they've got problems with insurance providers. And we've had clients come to us with problems with insurance providers dealing with other areas, other specialist legal areas, and we've been able to advise them on how to deal with their insurance provider, but we've not taken the case on afterwards because we haven't got a specialist PI solicitor that can take a case on, but we've nonetheless advised clients exactly what they need to do to challenge the insurance provider's decision, because we get people coming to us with those problems. It came about as a consequence of that, and it happened to be an employment case, and us realising, well, actually, we could do this. There's no reason why we can't be instructed to do this work, and then just generally carrying out research and basically learning on each case as to how best to manage these things. I think in the first instance, we didn't realise that a client had the choice of who to instruct once litigation had started. We weren't aware of that initially, and it's something we became aware of later on down the line. So.
Do you think I think it would be really helpful, at least for me, if I could have a look at your climate care letter, just to see how different, what you put in it that I would need to add to my own.
Okay, I think we've also asked for the same, haven't we, Upton? So yeah, what we can do is we can check some of our client care letters. As I've said, I mean, because of the terms of agreement will vary from insurer to insurer, the client care letter wouldn't always be a standard client care letter, because it would have to deal with some of the specific terms which we would generally attach.
Okay.
To the client care letter. So
you refer in
exactly what our obligations are to the insurer. Because I think some clients, I mean, we certainly have, in terms of, particularly when it comes to settlement, like some clients will want you to go up and up and up, and they just come to the point where you do have to say, look, I'm very sorry, I'm going to have to tell the insurer that you're refusing this very good offer of settlement. And that is in your client care letter.
What happens in such a case? Does that mean that the insurers won't fund anything?
No, they might refuse to fund it from that point in time. If
from that point in time.
To be honest with you, settlement negotiations happen so quickly most of the time, particularly if you're on the doorstep of a tribunal hearing. That's not likely to be an issue. But we've had it earlier on where it's potentially been an issue.
I missed the beginning, and I'm just looking at the typical cover includes, and you've got in the last point award of the other party's costs. So is that
okay? So that's not really relevant in insurance claims. I mean, sorry, it's not really relevant in employment.
No, I wasn't thinking for employment. I have basically we've been in practice. I do housing as well by someone who's got and litigation, but he's got a default cost certificate. So I was just thinking, he's got judgment to pay the other side's costs. So is that something potentially that could be covered, if you wanted to challenge it, could potentially be covered by legal? Obviously, you'd have to check with his particular policy, but is that something that?
I mean, it depends on whether his policy covered the area, and I mean, it's all about agreement in terms of whether. So, who's funded the case?
Well, he instructed us privately to just apply to set it aside at this stage, so just for the application notice, which we've done. But obviously, I can foresee he wouldn't have the money to pay for it. So, is that something? Just challenging costs to insurance companies, legal expense insurance normally cover something?
Well, they generally cover costs. It's not, as I said, it's generally not an issue in employment tribunal work. No. It can be sometimes. I suppose if there is the potential to make a cost application, you would be expected to potentially make it, particularly where the other side have been quite unreasonable. But it's more of an issue, I think, in civil litigation, like in personal injury claims, where costs are generally awarded, and that's why it would be covered, because it would be pointless for somebody to make it all the way through to the end of a case, lose their case that's being funded, and then still be hit with a large bill of costs. Any more questions? Okay. Jenny has handed out valuation forms. I really appreciate it if you can complete the valuation